constable in the presence of PW2, Chedram and one Bhagatram, leading to recovery of diesel pump, self-starter and toolkit from the house of accused Kisan Das. The police, after completion of investigation, submitted the charge sheet against the both accused for offence under section 303 Bharatiya Nyaya Sanhita 2023, read with section 3 subclause 5 Bharatiya Nyaya Sanhita 2023. A truck bearing registration number MP20 AB 845 owned by PW1 Mohanpal developed a mechanical defect and was parked in Blaze, Dumna on 21/1/2013 by the driver of the truck. And on the next day, a window of the truck was found broken and items including diesel pump, self-starter and toolkit were stolen. PW1 lodged on FIR XP1 and an investigation began under section 303 BNS 2023. During the course of investigation, the Kisan Das and his brother Ram Das were arrested. While in custody, the two accused made a disclosure statement under section 23 subclause 2 BNS 2023 before the head constable in the presence of PW2 Chedram and one Bhagatram, leading to the recovery of diesel pump, self-starter and toolkit from the house of accused Kisan Das. This clearly shows that the accused person Kisan Das and Ram Das are guilty of committing theft under section 3 subclause 5 BNS. The prosecution has established the offence beyond reasonable doubt through consistent evidence, legal recovery and corroborated witness statement. The theft is being established section 303 BNS. The stolen items, diesel pump, self-starter and toolkit were confirmed missing from the truck owned by the complainant Mohanpal, PW1. Mohanpal, PW1 provided direct testimony of the theft and lodged the FIR XP1 immediately after the incident, which proves prompt reporting and support credibility. The offence squarely falls within the definition of theft under section 303 BNS 2023. Defines theft as dishonesty, taking movable property out of someone's possession without their consent. Related case law है इजाज मोहम्मद versus State of Rajasthan 2024. In this case, learned counsel representing the petitioner vehemently urged that the petitioner is innocent person and present FIR file against the petitioner is false. That there is no record to show as to how ingredients of offence. Under section 303 subclause 2 BNS 2023, from other sided learned, the public prosecutor for the state has strongly objected the submission made by learned counsel for the petitioner and submitted that on the basis of material collected so far. It is observed that the petitioner herein is involved in a serious crime. The investigation is still in process. Thus, a chance of the petitioner escaping the procedure of law and with the evidence or threatening the complainant exists. Second case law, the State of Maharashtra versus Suresh 2000, SCC 471. It was held that the recovery of stolen property based on the accused disclosure statement is a strong piece of circumstantial evidence. Here, in the case also, the recovery from accused Kisan Das confirmed the offence of theft, the common intention, section 3, subclause 5 of BNS. The joint disclosure statement made by both accused during custody indicates common intention, and also it is not possible for normal person to delay stolen these heavy parts of the truck. It is clearly shows that there will be more than one person involved, and the stimulate initially recover of stolen property from the possession of one the accused. Kishan support charge under section 3 subclause 5 BNS 2023. इसमें केस लो है सर पांडुरंग तुगिया एंड भिलिया वर्सेस स्टेट ऑफ हैदराबाद AIR 1955 SC 216. It was held that section 3 subclause 5 is applicable when common intention is prearranged and the participation of each accused is established, and in the current case also joint disclosure and the recovery point towards shared intent and joint participation by both accused. इसमें एक और केस है किशन गोविंद पाटिल वर्सेस स्टेट ऑफ महाराष्ट्र AIR 1963 SC 1413. It was held that the common intention can be inferred from conduct and surrounding circumstance even without direct proof. Hence, no direct eyewitness and needed to prove common intention if conduct shows coordination. Thank you, sir.
Good morning, sir. May I proceed? I, Rohit Khare and counsel in the Honorable District Session Court. The defendant and counsel are rejected the prosecution points are as page number 5. Sir, to the defendant agar that the joint disclosure statement made by the two accused is inadmissible in the evidence. The truck registration number MP20 AB 85845 belong to one Mohan Pal, owner of the truck. Point number second, as the next day parking at village Domna to truck by truck driver Kishan Das. Point number third, the head constable arrested PW2 Chetram to custody in Krishna Das brother Ram Das. Point number four, the prosecution evidence no eyewitness. Point number fifth, Chetram was examined as PW2. He is silent with regarding making of the disclosure. Statement EXPW2 was Bhagat Ram, but he was not examined by the prosecution. Point number 6, joint disclosure. Statement is inadmissible under section 23 of BSA. The section 23 of BSA Act allowed admissibility only of such information from a person accused of an offence, and only that part of information which decently leads to the discovery of a fact. Point number 7, prosecution failed to prove disclosure and recovery through independent evidence. PW2 Chetram cheats as a witness to the disclosure, did not cooperate the alleged statement under section EXP2. Point number 8, the recovery allegedly made from the house of Krishna Das cannot be used against the brother accused in absence of the individual disclosure. Some regarding case law, page number 7. First case, State of Uttar Pradesh versus Devman Upadhyay AIR 1960 SC 1125. The Supreme Court said that the joint disclosure statement of the accused has no value in evidence. Every accused should have an independent statement. Point second case, sir, regarding Panduranga Kalu Patil versus State of Maharashtra 2002 AIR SCW 2786. The Supreme Court held that the accused cannot be convicted mainly on the basis of a statement made in the police custody, or there is no independent witness corroborated from the prosecution. Case number third, sir, Pullupuri Kottanam versus Emperor AIR 947 PC 67 is a famous decision of the private counsel which held that only the information obtained on the disclosure of the accused which lead the recovery admissible under section 27 Evidence Act. Rest of the statement is not admissible in the evidence. Page number 2. Such evidences of plaintiff in highlighted. Bhagat EXPW was Bhagat Ram but was not next examined by the prosecution, sir. Thank you.
Objection, my honor. My colleague said that the no witness was examined in in evidence and no reliance can be pleaded upon recoveries alleged to have made in pursuance of the joint statement. So, I want to present a disclosure of admissibility statement under section 23 subclause 2 BSA. As per section 23 subclause 2 of the BSA, only that portion of the disclosure leading to recovery is admissible. And the recovery of stolen items from the house of accused Kishan Das pursuant to the joint of the accused and Kishan Das pursuant to the joint disclosure is not only admissible but also changing evidence. Case है इसमें सर Puri Kotia versus King Emperors 1946. It was held that only that part of the confession and which deals directly to the discovery of a fact is admissible under section 23 subclause 2 of BSA. Hence, in the present case, also recovery of tools and parts from Kishan Das house following his disclosure is admissible and valid evidence. इसमें केस लॉ है स्टेट ऑफ यूपी वर्सेस दियोमन उपाध्याय AIR 1960 SC 1125. It was held that its discovery of the facts must be clearly connected to the disclosure made for it to be admissible. Here it support admissibility of record items take to the disclosure statement made in custody. And corroboration by independent witness to the disclosure and the recovery were conducted in the presence of PW2, Chetram and Bhagatram, enhancing the credibility of the investigation. PW3, Head Constable Shyamlal, confirmed the sequence of evidence and the recoveries for the strengthening the prosecution's case. And no explanation of accused. The accused has failed to prove any possible explanation for the possession of stolen article. No defense witness has been examined, nor any rebuttal offense which indicates that lack of credible defense. Thank you, sir.
To the court, some point to be considered. Point number first, page number 9. No CCTV image to prove the prosecution. Accused person are not liable. Sir. Point number second, evidence of prosecution. No eyewitness by the proof Kishan Das and Ram Das to thief the truck diesel pump and self starter and tool kits stolen. Point number third. Question mark, sir. The question, one person driving the truck. So 2% police custody in accused Ramdas and Krishnadas. Point number 4. Any magistrate not to be submitted the statement 24 hours of the accused person Krishnadas and Ramdas. Only the police statement should be convicted. Hence, Honorable Court to justice both person beyond reasonable doubt to accused. Thank you, sir.
Sir, I want to present with my argument. As per the prosecutions, Booth the accused while in custody on 21/1/2013 made a joint disclosure statement XP2 before Head Constable Shyamlal and PW2 in the presence of Chetram, PW2 and one Bhagatram, and in pursuance of the joint statement, recovery of diesel pump, self-starter and toolkit was made from Booth the accused. Therefore, on the basis of disclosure statement and recovery of the article offence under section 303 BNS 2023 was duly proved against Booth the accused. और circumstantial evidence recovery केस है त्रिमुख मारुति किरकन वर्सेस स्टेट ऑफ महाराष्ट्र 2006 10 SCC 68. It was held that when direct evidence is absent, circumstantial evidence, if conclusive, is sufficient to convict. In current case, no eyewitness of the theft. Here, but circumstantial evidence, disclosure of the recovery inconclusive. In another case, no है Sanwat Khan versus State of Rajasthan, AIR 1956, SC 54. It was held that accused failure to explain recovery stolen property and from their possession support inference of guilt. Here the accused fails to give any explanation regarding their recoveries items weakness its defense. So sir, please, I have a humble requested to you that you keeping in view all the witnesses and document, please give justice to victim state and a prayer. It is most respectfully prayed before the honorable court that the accused 3 subclause 5 of the Bharatiya Nyaya Sanhita 2023 as the prosecution has successfully proved the case beyond reasonable doubt through admissible evidence, lawful recovery and corroborated witness testimony. Humble submission made in the interest of justice. Thank you so much, sir.
Objection, sir. The prosecutions are failed. No forensic report and 3 PW1, PW2 and PW3. Mohanpal, Chetram and Shyamlal are the police staff. Also custody in Ramdas and Krishnadas. No truck number, sir, MP20 AV 845 by owner of Mohanpal to thief stolen by Krishnadas and regarding Ramdas diesel pump starter and toolkit. So at night not confounded such person with a reasonable doubt to convicted, both person acquitted, sir, for the justice. Thank you.
Sir, here is already mentioned the prosecution clearly shows that the accused person Kisandas and Ramdas are guilty of committing theft under section 3 clause 5 BNS. The prosecution has established the offence beyond reasonable doubt through consistent evidence, legal recovery and corroborated witness statements. So, sir, please the submission made in the interest of justice. Thank you, sir.